Hello and welcome to Amigos IAS. I'm Adnan. The Supreme Court today has ruled that the MPs and MLAs cannot enjoy immunity from prosecution for taking bribes, for saying anything, any speech inside the state legislature or the parliament, or for voting as per some directions. So in this backdrop, let's try to understand what is basically Supreme Court saying here and what are these parliamentary privileges. So to begin with, already I have done a video in detail regarding parliamentary privileges. They are mentioned in Article 105 and 194 of the Constitution. So please do check the description as well as the comment section to watch my detailed explainer on what are parliamentary privileges. Very important topic for the exams, guys. So let us start with this verdict. Supreme Court today unanimously, 7-judge bench has given the judgment saying that MPs or MLAs, if they take any bribes for saying something inside the legislature or voting as per certain direction, they cannot enjoy bribery. Supreme Court has overruled the earlier 5-judge bench case in the PV Narasimha Rao case in 1998, where the Supreme Court has told that the MPs or the MLAs will not be held liable if they accept bribes to vote as per certain direction, which is of course strange to understand here, but here the topic of parliamentary privileges become very important. So let's just jump into this particular topic here. So as you can see there, PV Narasimha Rao versus State 1998 case, in which the government was under minority and some of the MPs actually voted in favor of the government. A no confidence motion was introduced against PV Narasimha Rao government, who had a very thin majority. To save his government in the floor test, these MPs had casted votes against the no confidence motion. So they have taken the bribes. In that case, it was held that it is nothing wrong. So let us go into that aspect quickly. Supreme Court overruled its 1998 majority ruling, 3:2 it was. Members of parliament and state legislatures were immune from prosecution. Already I told this point, guys. So let us understand what is 105 and 194. As I told you, detailed explainer, please see my video. It is in the description. Basically, to discharge their duties without any kind of fear, because the MPs or MLAs are people's representatives, it is essential that they should not have any kind of restrictions on what they say inside the house, what kind of speech they have, what kind of the kind of voting they do. Or let's say, because these MPs perform legislative duties, there should be no restrictions inside the house. Whatever the action is there, the speaker or the presiding officer can take. The courts will not involve into the proceedings of the parliament. So keeping in tune with this, already in the UK, the House of Commons gives these privileges for its MPs. So India also has taken the same concept from the British Constitution or the British practices. So these articles 105, 194, they give some kind of immunity. Let's say an MP or MLA cannot be arrested 40 days before starting of the session and 40 days after the session in civil cases. No action can be taken against the MPs or MLAs for any kind of speech they give inside the house. Unlike us, the restrictions of 19 Clause 2 do not generally apply to these MPs and MLAs. These are called as privileges, special rights given to these MPs and MLAs. And now, does it also cover the bribes? That is the question which we have to answer here in this particular case. These provisions provide them freedom of speech, as I just told you. That means an MP and MLA cannot face defamation, which is a ground of restriction under Article 19 Clause 2. Against freedom of speech and expression, 19 Clause 1 subclause A has restrictions in 19 Clause 2, where defamation is also a ground. This will apply to people like us, but not to these parliamentarians. That is the advantage they enjoy. Fine. And what was this judgment of 1998 about? As I told you, 3 MPs, Jharkhand Mukti Morcha MPs have taken some kind of bribe to vote in favor of PV Narasimha Rao government, and you can see government survived with a slim margin of 265 votes in favor and 251 against. A year later, when the allegations came that those MPs have taken some bribes in support of the government, the cases were filed, but Supreme Court held that the MPs and MLAs are immune from prosecution because they kept their side of the bargain. Now, what does this mean, keeping the side of bargain? I'll just come back to this in a while. Now, what the court has told, whether giving a bribe to commit certain action, that itself is an offense, because we have Prevention of Corruption Act 1988, where if you accept the bribe, no matter what you are doing with that bribe, that doesn't matter here. The action what is taken after you take the money does not matter. But in the 1998 judgment, the Supreme Court has told that if someone is keeping their side of the bargain, that means I took bribe from you and I told you that I am going to vote as per what you say, then no action shall be taken against me. Does this mean that if I take bribe from you and if I don't vote what I am promising to you, then can action be taken against me? So how does this actually work? That means if I take bribe from you and vote as per your direction, no action against me. But if I take bribe from you and if I vote against you, then action can be taken against me. It's a paradox. So what the court has ruled today, regardless of what action you do after you take the bribe, taking bribe in itself is a criminal offense, and parliamentary privileges are not applying to criminal offenses, they apply only for civil offenses. That's the crux of the argument here. So court said that protection of these privileges do not apply to the members, because it is not a duty you are performing here. Voting as per certain directions or taking money to ask some questions, these cannot be claimed as immunities. The court has given clarity today. The court warned that such protection would create a section that can enjoy unregulated exemption from law. Corruption and bribery, as the court has emphatically mentioned, that they erode the foundations of the parliamentary democracy which exists in India. So very big words the court has used today. Article 105 is to bring some conducive environment for discussions. That means for any action you take or the votes you do for the sake of the larger interests of the public, or as per the directions of the house you do it, not to satisfy somebody's requirements. Bribes is an offense, guys. Okay, so environment is destroyed inside the house if you take money to do such an actions, guys. So court also pointed, unlike the British House of Commons, in India we do not have a proper codification of the privileges, guys. We have taken these as per the UK's House of Commons. As per 44th Amendment Act 1978, we omitted the reference of House of Commons. Okay, and we have told that whatever the parliamentary privileges are existing since the commencement of constitution will continue. But in India, we do not have any proper law, proper codification of privileges does not exist in our country. Because of that, earlier it was statutory, now it has become constitutional, but they are not like the kind of privileges the parliamentarians would get in UK, because at that time in UK, the English Civil War happened and then Glorious Revolution also happened. Clash was there between supporters of the king and the parliamentarians. So there they had to give clarity about what privileges the parliamentarians have vis-a-vis the king or the monarch of England. That is why they are having a lot of seriousness attached to those privileges. In India, it's not the case, because we don't have such history what UK had. Hope you got the point. So whether a claim to privilege in a particular case conforms to the parameters of the constitution is amenable to judicial review. That means judicial review is applicable here. Generally, as per Article 122 and 212, the courts shall not inquire into the proceedings of the parliament and state legislatures. But now in this case, they can involved, because it's a matter of bribe, guys. Okay, and prosecution on charge of bribery in connection with vote or speech, you cannot claim immunity. Already this point I repeated several times, guys. What is this twofold test? I'll just come back in just a minute. Okay, so offense of bribery is complete at the point in time when the legislator accepts the bribe. As soon as you accept the bribe, offense has been done. It does not matter whether you are voting as per the person who has told you, who has given the bribe to you and told to vote as per some direction. If you follow or not follow, does not matter. The offense has been committed the moment you take the bribe. I hope you got the point. Okay, the interpretation has been placed on the issue in the question of P.V. Narasimha Rao judgment, where they have told the otherwise case. Okay, that means if I give you money, you take the money, you vote as per my directions, no prosecution, nothing happens. But if you don't vote as per my interest, prosecution happens. Logic nahi hai, isme koi nothing is much is there here. Okay, and the last to conclude here, the court also laid a twofold test that when the lawmakers enjoy immunity under Article 105 Clause 2 and 194 Clause 2, what are those conditions where I can claim immunity, guys? First one, immunity will apply if there is a collective function of the legislature which is involved. That means if I am discharging certain important legislative duty which involves the collective function of the house, then I will be able to claim immunity for any action of me. Okay, not for the bribes. The act in question must be related to the discharging of the function of the house. It means for functioning of the house, whatever the activity I am doing, there, for example, let's say an important bill is being passed and there I have told some objectionable remarks. That time I will not be prosecuted. But me taking a bribe for the function of what any elections of any legislature or for the president or vice president, there if I take bribe, I am not serving any larger function of the house. That is not considered as a legislative duty. And this will apply to election of members of legislature, Rajya Sabha, president, vice president also, the court has clarified. Because this case, why did it come up? It come up because of the 2012 Rajya Sabha elections in Jharkhand. Sita Soren, the MLA, was charged by the CBI for taking the bribes for voting for an independent candidate in the Rajya Sabha elections going on at the time in Jharkhand. She's accused to be taking the bribe for voting for an independent candidate, and CBI will file a case against her. She will go to the High Court and they will refuse to stay the case, and then she will go to Supreme Court. After 2 judgment and 3 judgment, they will say already PV Narasimha Rao case deals with this aspect, which is a 5-judge bench. So the matter should be heard by a larger bench. That means what? 7-judge bench in this case has heard this particular case, guys. So I hope you understood this particular topic. If you have any questions, please post in the comments. I'll be happy to clarify. Keep watching Amigos IAS. Thank you.